So before we get going, we just wanted to do a quick land acknowledgement. The presenters acknowledge that we are residing and working in traditional lands of the Anishinaabe and Haudenosaunee people subject to the Dish with One Spoon and Bushwana Wampum covenants. And I also just wanted to let people know about the structure of our talk today. So we're going to do a couple of segments. First, we're going to talk a little bit about the barriers to access to justice that we've seen in our work and some practical strategies as organizers, as litigators to try to address those barriers and some stories from our work. Then we're going to break for questions, so be prepared. There will be a break for questions. And then we're going to talk a little bit more about the role of law in trying to work on systemic social justice. And then we're going to break for questions again, and then we're going to have a final segment, and if we have time, break for questions. We'll see. First of all, we're going to just, each of us do a very brief introduction. So I'm Eric Yackman from IAVCO Community Legal Clinic. IAVCO is a legal clinic that works with primarily low-wage and precarious injured workers, and we have a special interest and focus on working alongside migrant workers in Ontario. So I'll turn it perhaps to Faye next to me.
Hi, I'm Faye Faraday. I'm a social justice lawyer. I do work on labor, human rights, constitutional law, representing workers. And I've been working with migrant workers for 28 years.
My name's Shane Martinez. I'm a private practitioner in Toronto. One of my main areas of practice is human rights law, with a specific focus on migrant workers who are here under what's called the Seasonal Agricultural Worker Program, which you'll probably hear referenced more than a few times during the talk. And those are typically workers who come here from Mexico and the Caribbean and work on farms throughout Southern Ontario and also across Canada.
So good morning, my name is Chris Ramstrup. I'm the non-lawyer of the panel, the only non-lawyer here. I'm an organizer with Justice or Justicia for Migrant Workers. For the last 17 or 18 years, we've been going to farms across Ontario and working, I think, with everybody on this panel to both engage in organizing and developing legal strategies to smash the state. Thank you.
Hi, I'm Jackie Esmond. I'm a staff lawyer at the Income Security Advocacy Centre, which is one of the Ontario legal clinics funded by Legal Aid Ontario. Our clinic specializes in test case litigation, advocacy, and community organizing around access to government income supports like social assistance, employment insurance, and so on. And we also do work around workers' rights for low-income and precarious workers. Our clinic is also a member of Migrant Workers Alliance for Change, which is a coalition of national migrant workers groups, grassroots organizations, unions, faith groups, activists, and researchers. And so a lot of our organizing work is done through that organization.
Good morning, everyone. My name is Grace Vaccarelli. I'm a lawyer at the Human Rights Legal Support Center. The Human Rights Legal Support Center is not a legal clinic, but we're similar to a legal clinic. We provide legal services to people across Ontario who believe they've experienced discrimination. We provide intake, advice, and representation throughout the human rights process across the province. We provide services in every language and try to support migrant workers as we can.
Thank you. All right, let's get to it. All right, so first thing is I've asked Faye and Chris to summarize the structural barriers obstructing migrant workers' access to justice in 8 minutes. So I apologize. I'm going to turn it to Faye first.
Okay, so 4 minutes, no time to waste. The main access to justice barrier for migrant workers is the fact that this is a system that is entirely designed to harness and leverage inequality and precarity. Our participation in labor migration programs are part of a global system that is about leveraging that inequality between North and South. You do not have temporary labor migration programs unless there is sustained structural inequality. And it's part of a growing movement globally over the last 3 decades, which has seen colonialism and transnational corporate imperialism displaced people from their homes, from their communities, has eviscerated economies around the world, creating a population that is subject to involuntary migration for survival. And those of us in receiving countries profit from that. So it's a system that's designed to normalize and sustain circular migration. That's the biggest structural barrier, and one that we often don't talk about, how we are participants in that. It's a global structure that is profoundly racialized, and that entrenches those inequalities here in Canada. The laws that have been established to channel labor migration themselves put very strong restrictions on labor mobility, labor rights, the capacity to enforce rights, and the injustices that we see are not unpredictable or accidental. Part of the design is to deliver a complicit, disempowered working class to at low wages and at a level of low rights to be able to support economic development in Canada at lower levels than are recognized for Canadian workers. And unless we actually come to grips with the system in which we are complicit, there is no possibility of real justice. 3 minutes.
All right, I will try to ramble for 6 or 7. So I think it's important to just follow up with what Faye was saying, and for us to think about, and Sang Hun had mentioned this beforehand, well, what are we really trying to achieve? And that is power. And how do we challenge power? And how do we break the power of the employers and the government who do not want to listen to workers? The system that we're fighting is a system that's based on the legacy, keyword legacy, of both slavery and indentureship, and the way that the laws have been formulated to deny working class racialized people the ability to exert their rights. Now this morning when on the TDC, of course I do everything last minute, I started thinking about those legal cases. And the first thing I want to put forward is most of the legal cases that all of us have been engaged with have been last resorts. And this means that a strategy of last resorts. And this is when workers have been terminated, when they've been fired, sadly when they've been sick or have passed away, with the exception of 2 larger cases, and I'm sure Shane's going to talk about the DNA case involving a group of Trinidadian and Jamaican workers involved in the police near Tillsonburg, Ontario, and De Jesus was a case with employment insurance, which I'm sure Jackie will talk about. So very much it's a last resort strategy, number 1. Number 2, the laws already do not work for us, and there's many exclusions when it comes to health and safety, to employment standards, and of course we know it's illegal to form a union. So the existence of laws for many other communities don't exist for agricultural workers. So that's number 2. Number 3, it's the idea about disbarment. Some people will call it banning. But when workers do come forward, there's another case maybe Meredith may talk about of a worker named Curtis Hazel, another Trinity worker, where he came forward to bring his case forward. His name ended up on a list of workers who were banned from the program in Trinidad. So the disbarment, the repatriation, the inability to work afterwards, the absence of real protections through power and power imbalances, both through what the growers have and what they engage in legal strategies. And I know my lawyer friends don't, they have to play nice with judges, but I don't. And I think that some judges, well, the entire system is racist. But you have particular judges there who are so out of touch. And I think with the healthcare case that we had, the Clark case, you saw this really racist dynamics where the idea about Caribbean and Mexican workers having equal access to healthcare was seen about opening up the hordes of the masses of people from the global south to have access to our healthcare system. So this is the mentality and the ideas that many of our people involved in the judicial system have. So there's an absence of analysis of the context of why people migrate, which Faye so eloquently brought forward, and any understanding of what happens, what are those racial, what are the gender dynamics that exist on our farms today. And lastly is the contradiction that exists. So we may engage in a legal strategy, but it can also hurt an organizing strategy because of the resources. So if you have a choice, everybody here is funded by the government, right? These are access to justice is a huge issue. So if you've got resources towards a case, you've got two choices. You put money towards a case, you put money towards organizing on the ground, number one. Number two, the other side's always going to engage in delay tactics. They're going to try to run your bills, right? Meaning they're going to try to basically make you waste your money, right? And that's the thing. They've got infinite resources. We saw this in the Fraser case, the right to organize, where besides several unions and us, it was like everybody, their grandmother and their brother and sister were basically trying to stop the right to organize for farm workers. So resources, contradiction between organizing, what you do on the ground versus the legal strategies. And I guess finally, it's just thinking about the narrative and what type of narrative do we want to put forward? How much time? All right, so
2 minutes.
2 minutes? And when I say narrative is what type of story we try to develop about workers. And there's a certain prism that I see, particular bodies. So somebody who engages in a case, I've seen people been positioned as so-called vulnerable exploited workers or people without any agency. I've seen other people dressed as trying to say that they're trying to scamming the system. People who try to take these cases forward. The Prestige case is an important case for that, where they try to say the women were trying to scam the system. And then simultaneously, other people were just trying to say that people are vulnerable. The challenge for us is to understand that vulnerability, which I think everybody here has been involved in a case involving this idea about vulnerability and exploitation, comes from the system. It's not based on the individual and the person. And a lot of times there's this default where we think that the worker themselves are somehow poor, stupid, don't know their rights, and that's not the case. It's a system that constructs vulnerability, and that needs to change. So it's about thinking about what type of resistance strategies we can organize, and how do we use the law to build power, even when we lose. And that is the story that we need to tell. Thank you.
Thanks, Chris. So let's think about what the heck does that mean to us all as lawyers. What practical strategies do we use? What do we recommend in working alongside migrant workers in litigating their access to justice? I'm going to turn it first to Grace and then to Shane and Jackie, and you have about 3.5 minutes.
Sure. So the other piece about the structural barriers that our clients face is English may not be their first language. They live in rural areas. They may not have access to transportation. And so if they amazingly get to us, right? And that's the first step. They have to get to us, and we have to thank Chris mainly for our clients.
All these people here.
And other people here. I know Chris here has gotten lots of clients to us. We need to collect that evidence very quickly. So we need to allocate significant resources immediately. We need to get the translators on board. We need to maybe get affidavit evidence. We just need to make the time then when the person gets to us to collect that evidence, because the evidence may be gone if the person is deported, right? So we just need to be sort of practical and strategic about right now, what do we need to collect? Anticipate everything's going to take a longer amount of time. There's the need for translators. There is the need to explain the legal system. You need to build trust with people, so that you need to take that time to build that trust, build that relationship. Explain the role, like how the legal system works, and your role in it. So as lawyers, we take instructions from our client. Our client needs to be the one sort of driving the bus, and we're following their instructions, so that takes some time. You know, lots of times people come to us and they say, well, we just want to make a complaint, and you deal with it, because they know the risks that they inherently have in bringing a case forward, and that our legal system doesn't allow you to do that. So that's, you know, explaining all those risks takes some time. The other thing, I don't want to, I lost you every things, but the other really important piece is to have a strong legal referral and a community referral. So I do human rights work. I need to have an immigration lawyer that I can trust. I need to have a housing lawyer. I need to have those other referrals there. We don't want to just give people phone numbers, because we don't want anyone to fall through the cracks or get on a phone and wait 30 minutes to speak to somebody. We want to make the direct referrals and make those connections so that it's a straight link to the next resource that the person needs, including the community organizing and the housing referrals and all the other potential referrals. I often, in terms of the legal referrals, I may need to talk to that immigration lawyer because that is a big risk. And so I often get my client to sign a consent form right off the bat advising the immigration lawyer and myself that we can have those communications because we have privilege. I can't talk about my client's case with anybody outside, so I make sure my client knows that I'm going to need to talk to those other lawyers, get those consent forms signed right off the bat, and explain to my client that everything that I learned from the other lawyer is also confidential. I won't be sharing that with anybody else. It's just sort of practical things at the front end I think about. And I'm sure I have lots more to say, but sort of my panelists, I think.
Shane, any other?
Sure, yeah. I mean, Grace hit on a lot of what I was going to mention, but I think it comes down to as well a question of, I guess where I'm coming from is as a private practitioner as opposed to coming from, a clinic or a institutional setting. And there are, for lawyers who are in private practice, a lot of sacrifices that you have to make taking on this kind of work. All of the human rights work that I do for migrant workers is done on a pro bono basis, and so it involves, a lot of long car drives with Chris and other people in Justice for Migrant Workers down to Tilsonburg, Leamington, Simcoe, late nights down there meeting with people when they're available. These are people that are working, 6 days out of the week. They typically only have Sundays off. And so it's about making sacrifices, I think, in your own life, and also figuring out what your own orientation is and the reasons why you are doing the work, which I think builds up over time after getting to know workers who are actually out there in the fields that are toiling there and bringing the food that we consume here in Ontario to our tables. But for them, the entire concept of Ontario agriculture wouldn't exist. And so I think that it also has to do with, talking about practical strategies, it has to come up with, we have to create very innovative ways about communicating with people. A lot of the times when we're down there, Chris and I, we'll come across workers who, they don't have a telephone number that you can reach them on at all, but they will have a cell phone that when they go into town, 1 or 2 days out of the week, they'll go and to a coffee shop and they might be able to connect to Wi-Fi there. And they'll say, oh, send me a message on Facebook or on WhatsApp or on this or on that. Mediums that typically you wouldn't communicate with a client through. But understanding that these are the circumstances that they're in, you have to kind of develop new ways to still have that kind of a professional relationship using different means. And also, just I think ensuring that the workers themselves are engaged in the process as much as possible, that they can take ownership of it, that they feel vested in it, that they know that it's theirs, instead of just, oh, here's a lawyer, he or she's going to fix the problem for me. It's not about that. We want you to be actively involved in the process. And when you're contending with people who are here, in a very precarious state, they're here for some months and then they're back home and then they might come back. There's a lot to work around in terms of ensuring that people stay engaged, because you're often dealing with people who are from very remote communities in their home countries. So it's ensuring that you don't only have a phone number for that person, for example, when they go back home, but you also have their cousins and their neighbor's phone number, and you have all kinds of different ways that you can reach out to them and make sure that they stay connected. So it's just becoming creative in terms of, I think, maintaining communication. That's a really big part of it.
That's great, thank you. Jackie, we left the worst part for you, which is go last.
Yeah, those are some really great practical suggestions. From my own experience, I would say that the one big case that I was involved in, Chris mentioned it the day he was his employment assurance case. I came in kind of later in the process, so all the work of building that case at the beginning was done by others. So I can kind of tell you what I saw that worked from that and what I would hope would be recreated in other cases. And I would say the first thing is that relationships are really central and critical. Grace talked about having trust. We're talking about workers who are putting their jobs and their livelihoods on the line if they bring forward a complaint. And they're not going to do that lightly, and they're not going to do that with somebody who they don't trust. And so how do you build that trust? It means actually being on the ground, being in the communities, and being connected to organizing. So it's not my job as a lawyer to sit in my office in Toronto and dream up the perfect legal arguments and what I think would be a good case. Comes from the workers themselves the workers' priorities, what they want to do, what they feel safe doing. So I would never want to do a case involving migrant workers without, if it's in Leamington, then I better be connected to Chris and Justicia. And there has to be a whole network of people around that, not just me. And that you also need to have really thought through and have a plan when reprisals happen. So it's not something that you're going to come up with on the fly. If you're starting a case, then you from the beginning are thinking, what are we going to do if a worker gets fired, if they're at risk of deportation? That's all stuff that happens really fast, so you need to have a plan before it happens, so that, do you have your immigration lawyers lined up? Do you have emergency contact numbers that people can text or WhatsApp or whatever if there's a raid or if there are mass firings? So that means you're going to be talking to the workers about what risks they see and what plan they want to have in place when reprisals happen, because they just will. And then the last thing I would say is I really agree with Chris that for the most part, the cases that are going to be able to go forward are the ones where somebody's already been fired, somebody's already been deported or injured, or the target is safe. So the employment assurance case was not a threat to the employers. It was about access to a government benefit program. Workers still had a lot of concerns, and Chris was really very involved in the organizing in the early days. That still didn't feel safe to many workers to do, but it is somewhat safer than some other options where workers are at real risk of being barred from coming back in future years. So those are just some of the things that I would think about if I was launching a case.
All right, now we have one of the most difficult questions I've ever seen. So, especially for some of our panel who have 20, 30 years of experience in this area. But I'm going to ask everyone on the panel to tell us about one case or issue or experience that sticks with you for good or for ill, and what you learned from it in 2 minutes if you can. Maybe starting with Grace.
Well, do you want to switch it up this time? I can start again. Okay. And I also think Meredith should tell us some stories as well, because she's done a lot of this work. So the one big case I was involved in was Prestige Workers. Prestige was the company. And the applicants in the end were two women, OPT and MPT, who were sisters. So a little bit about this case. It originally started with, I think, 39 migrant workers who were working in a fish processing plant. So this is not under this, they're not seasonal agricultural workers program. There's another program for low-skilled workers, and it's a different program. You come for 2 years, and you can come for a certain number of years, and the max I don't know to come for a little bit, and then you can come. So this fish processing plant was a unionized workplace, but the union had no idea that they had, I don't know, hundreds of migrant workers working in the plant. I think one of the shop stewards said, "Oh, where are all these workers coming from?" And the employer said, "Oh, they're not part of the union," and that was it. So down the road, though, they did hook up with Justicia, and Justicia was able to connect them, let them know that they were unionized. The workers alleged differential pay and sexual harassment and sexual assault. And a number of workers came forward, and the union filed applications, bit botched up at the beginning, thinking they could file without their consent. It's a bit of a mess at the front end. Lots of procedural things happened. Justicia, the center represented Justicia in intervening in that application and bringing forward the social science evidence about the structural vulnerabilities that, or barriers that exist to migrant workers. In the end, the 2 migrant workers were left. So the case settled along the way for all the other workers, for those that were still there, that didn't get dropped off for other technical reasons along the way. And what I found sort of most telling to me, so the abuses were, OPT was repeatedly raped by her employer and forced to engage in all sorts of sexualized conduct. to keep her job. And her sister was deported because her sister did not follow the house rules and decided to go for a coffee when she wasn't supposed to go for a coffee. The employer, as you may know, often has employment and housing connected to the employment relationship, where they have all sorts of rules, and if you don't like them, you're deported. And he developed sort of a survivor game where they had to vote on whether she would be deported or not. So just sort of dividing workers within. And so it was the most sick case I've ever heard of, in fact. But what was shocking to me, was the facts were shocking, but the expert evidence was that this is kind of commonplace. So the expert evidence, we had Carrie Pribish provide expert evidence at the hearing, and she did, so we had a witness in, she was our witness, and she gave lots of evidence about the structural vulnerabilities, but the gender-specific vulnerabilities that she explained, and I'll go through some of those that were in our witness statement, were exactly what these women experienced. They may have had other ones. So then I thought, so this isn't an anomaly. This isn't just this one farm worker. This isn't, or sorry, these two workers in this fish processing plant. This is being experienced across hundreds and hundreds of workers, and women workers in particular, as this case was about the gendered experience of migrant workers. So some of the evidence that she gave that we also saw in this case, that women are subject to intense sexual harassment from co-workers and employers. Accommodation in employer-provided housing increases the risk of sexual harassment and violence. High number of women participating in guest worker programs are single mothers and often heads of households. So we also saw that. So these are women who's lost their spouses and had to raise their families, and this was the only access that the only way that they saw they could. Within the country of origin, women are living in high levels of gender inequality. Women's employment options are highly limited and poorly rewarded. As a result, women may be more willing to acquiesce to employer demands in order to retain their jobs in Canada. And this comes down to what Faye goes back to, right? We live in a system where we're dependent on less options in your home countries. Women are threatened to be replaced with male workers. Women face greater restrictions on mobility. Women's movements and sexuality are highly constrained by practices restricting women to employer-provided housing, prohibiting or curtailing visitors of the opposite sex, and establishing curfews. So those are just some of the things that was the evidence, and that's what we saw. And for me, what was most striking was Dr. Pribish has interviewed hundreds of women coming to these conclusions, and I know that the two women that we represented weren't actually been interviewed as part of her study. So this is how widespread this abuse is. So that's not a happy note.
Continuing with the unhappy notes, I guess I'm going to talk a little bit about the employment insurance case that I mentioned, and the lesson that I learned from it is sometimes when you lose, when you win, you still lose. So this was a case where it came out of organizing. And generally, in the employment insurance program, with every paycheck as workers in Canada that we pay into the employment insurance program, it's supposed to be there for us when we lose our jobs or go on parental leave. For migrant workers, access can be extremely difficult. Most migrant workers will be turned down either correctly or incorrectly for regular EI benefits because you have to show that you're ready and available for work, and if you don't have a work permit that's open, that allows you to openly engage in the labor market, then that can be hard to establish. So there was this exception for parental benefits. Many of you may know, to access parental benefits, you don't actually even have to be in Canada. Because you don't have to be ready and available for work, you're expected to be caring for a child. So there was this exception where migrant workers, seasonal agricultural workers, who, if they went back to their home countries during the 4 months between contracts, and if there was a newborn in the house, then they could access parental benefits. There was a real lack of information about that. There was a real campaign. Chris was very involved with that, centers in the communities where migrant workers work were sharing information and helping people to apply. So there were actually thousands and thousands of applications for parental benefits going back like 20 years asking for back pay. And for a while, employment insurance was granting those, giving people parental benefits. And then suddenly, I think it was in 2008, they just stopped. There was no change in the law. They just stopped giving, they call it anti-dating in the EI world, but it's like about an extension of time if you apply late. So the case that I was involved with involved 102 migrant workers who appealed the denial of their parental benefits. And that eventually made its way up to the Federal Court of Appeal, where the Federal Court of Appeal said, you have to take into account the vulnerabilities of seasonal agricultural workers, the language barriers, they're in rural communities, the risks that they face, the structural inequalities in the program, and take all those into account in order to, and give extensions of time. And so ultimately, all 102 workers did get their parental benefits with the applications. But in the meantime, the conservative government, Harper was in power at that time, just changed the law. So the law is now that if you're a migrant worker and you're out of the country, out of Canada, then you don't qualify for parental benefits. Any other worker, if I had a child and I left Canada during a parental leave, I would be able to access parental benefits. Migrant workers cannot. And that remains on the books with a change in government, despite lots of advocacy to try to change that. So although we were successful for 102 workers, that gain was taken away from everyone else. So that's a risk you have to take into account when you're litigating as well, because sometimes government responds in ways that make things worse.
All right, so I was doodling while everybody else is speaking here. And I guess what I just kind of realizing is how everything really is connected here. So I want to talk a bit, well, okay, so everybody's like, so Chris shows up and yeah, all these things happen. That's not actually the case. So all our outreach with Justice for Migrant Workers has been painstakingly pain in the ass over years, just talking to workers, showing up, having them kind of curious who we are. I still think a lot of people, many workers are terrified. They're not going to talk to us. But it's after building those long-term relationships and then achieving tangible benefits. So it was through the legal clinic system and Consuelo Rubio who had the EI, these parental benefits. The parental benefits for us wasn't just simply a charity model. It was about building, organizing, getting somebody a tangible benefit and then trying to see to use that to build trust with workers and then to build power. And that also led us to organizing with other workers. So the DNA case that Shane will talk about probably is connected to that work of the EI and getting those EI benefits. The Prestige case, which Grace talked about, is also linked to another group, Adrian Monroe's, who Shane Martinez had represented, a case of a Caribbean worker who faced anti-Black racism in the workplace. And how they were connected is that the community organizing was happening, and we were having a house meeting with a group of the Prestige workers, and then all these workers from St. Lucia showed up, and were like, well, we've got a problem, and can we talk about this? And the unfortunate thing about this is you had this group of workers who were all facing the same racial discrimination in the workplace. They all got sent home. And then other workers, other missed deadlines, they basically went AWOL. And Adrian was the only one that was able to speak or to go have his case forward. So for each one of these cases, I think exactly what Grace said represents hundreds, if not thousands, of other narratives and stories. Part of this longer chain of EI is a worker who was murdered a couple years ago, Curtis Hazel in Trinidad. And Curtis was also brought his case forward when he was doing construction, when he went on a non-agricultural work. And he was facing serious forms of discrimination in his workplace as well. So my point here is that the organizing in all of these cases, they're connected, one through long-standing work, outreach, friends of friends. When you actually deliver something, it's friends of friends are like, yeah, well, I'm in Tilsonburg, I got friends in Simcoe, or I have a cousin in Chatham, or I've got family members, or my ex's ex dated somebody in Leamington. So those larger networks are what help to build this. And through this process, it is not perfect. There's lots of bumps, and there's lots of learning reflections. The last thing I think is both the worker injuries and worker deaths. That I know that anybody who does workers' comp, or just the travesty of injustice for all these workers in the Caribbean, Mexico, who have been injured and sick and have just been disposed of, and connected to that is all the workers who've died, and just dealing with the families all these years. The Hampstead accident, which happened close to Stratford, and just knowing those families didn't receive any real justice. Ned Peart, Sheldon McKenzie. There's a brother who died last year in Leamington, and there was no noise about that. So that, and just knowing those things, they keep you up at night, definitely. So I think for all of us, if you don't mind me speaking, this is not about getting rich or just, making a career out of this. It's about those families demand some form of justice. They demand answers. And part of the answers that we want to give is to make sure this doesn't happen to the next generation of workers.
And yes, I'm going to talk about those two cases that Chris mentioned. Right now, I'm just going to talk about the Adrian Monroe's case, and then maybe a bit later we'll talk about the DNA case. So the case involving Adrian Monroe's was a case where he worked for a place called Double Diamond Acres, which was a tomato greenhouse operation down in Leamington. And what had happened is that Adrian and a number of the other workers there were from St. Lucia, and one of the supervisors at the greenhouse had a habit of using racist slurs against them when they were there and they were working and they were picking the tomatoes. So one day Adrian got upset and he confronted the supervisor about it and expressed that he didn't want the supervisor using racist slurs towards them anymore. And as a result, he was taken off the line. He was put in the bunkhouse for a week. He didn't get any work, and then they came to him and they said, with less than 24 hours notice, you're going home, pack your bags, get off the property. Here's your airline ticket, go find a bus and get out of here. So he was obviously very upset. He's not even able to pack up all of his belongings. He's essentially chased off the farm. They called the police to get him off even more quickly so he doesn't have a chance to talk to the other workers. And they essentially use him as an example, right? About this is what happens when you complain. Like if you want to come and confront us about how we run our farm, this is the fate that you're going to have. So Adrian ends up getting repatriated, deported back to St. Lucia. But what I guess they hadn't realized is that he had a relationship with a woman up here. The relationship continued even though he was gone. She sponsored him to come back. He came back, got in touch with Justice for Migrant Workers, and then this was about 8 years ago when I was an articling student. He filed a human rights application, and so we were able to refine the human rights application, touch it up a bit, and then eventually it went to a hearing. So I went on and I started practicing law, and it was one of the very first cases I did. I ended up taking it with me when I left the clinic, and we did it pro bono when it hit the tribunal. So when we got there, the lawyer for the other side, for the farm, and I'm trying to wrap this into what I learned from the experience. The lawyer that represented the farm was from one of if not the wealthiest, biggest firm in Windsor. He had been a lawyer longer than I had been alive, and I was just like, oh wow, how am I going to do this? They've lined up all these witnesses that they're bringing in. We only had Adrian plus an expert, a professor who was going to come in and testify, Tanya Basak, about the program. But at the end of the day, through working closely and investing the time with Adrian to prep him to testify, the same way, but even more intensely that you would prep a witness, who lives here in Canada, or a litigant who lives here, and just carefully working with him, getting him ready for cross-examination, helping him understand exactly how the vice chair was going to decide the case, helping him understand the questions that would be coming from the other side, getting him comfortable with the process and understanding both the law and how the laws applied to the facts. He did absolutely phenomenal. We were able to prove, and I mean this in the most literal of ways, that the employer lied multiple times, and the tribunal recognized this, and it was borne out in the transcripts. And it ended up being the very first successful case for a migrant farm worker in Ontario. And so he received damages under the Human Rights Code. He also received lost wages, and he's still here today. He made it back here, and he's still here today, and that case has thankfully been able to be a bit of a gateway to help other cases go forward. So what I learned from that one I would say is that if you invest the time and the patience that's necessary, that even through one case with one applicant, you can make some significant gains, especially in a situation under the Seasonal Agricultural Worker Program where, keep in mind, the program has been operational for 50 years, and it took until, if I'm not mistaken, 2013, it took quite a while for the decision to come out, that we had the first successful case ever. So a system that is rife with human rights abuses, it took that long for the very first positive decision to ever come out, right? So that obviously illustrates a problem with access to justice there, and it shows why we need to invest that time and that attention to make sure that any case moves forward and is successful.
So I'm going to return to the story of this defeats. And losses in the system. There's many more of those than the wins. We absolutely have to celebrate the wins and recognize when they happen. But the case that sticks with me out of my entire career is the Fraser case, which is the case advocating for workers' right to join a union, to bargain collectively, to engage in collective action. And it comes back to what Chris was saying about how at the bottom what workers need is to be empowered. They need to have the capacity for collective action without reprisal, and the right to collective action, to freedom of association is, I think, for all citizens and all people living in community, one of the most fundamental rights. It's what gives us power. And farm workers have been excluded from those rights from as long as there have been laws in Ontario. The process of building the groundwork to make arguments, even get to the door to be able to make arguments for farm workers' rights to bargain is something that I've been working on literally since my first case as a lawyer. So this is decades of work. We went through, there have been a series of cases that gradually built the recognition in law that the right to join a union and to bargain collectively is protected as a constitutional right and as the most important exercise of freedom of association in the workplace. So those each, beginning in the mid-90s, built the legal principles that allowed us to bring the Fraser case forward and say farm workers are excluded. This is clearly a violation of constitutional rights. Just change the law. And we had 40 boxes of evidence. I lived and breathed this case for a decade. We had evidence about the history of the laws going back to the mid-19th century. We had histories of the Seasonal Agricultural Worker Program going back to the 50s. We had histories of labor migration programs in agriculture going back to the home children in the late 19th century, setting up that really deep structural foundation of precarious work in Canada and the deeply racialized roots of the exclusion of bargaining of farm workers, which is rooted in slavery in North America. We had deep, broad evidence about the discriminatory impacts on migrant workers, that migrant workers are racialized workers, the way in which the program is structured in order to have the countries compete against each other to send workers in a way that depresses worker rights, et cetera, et cetera. We had all of that. And we got a unanimous decision from the Ontario Court of Appeal, a decision from the Chief Justice, of the Ontario Court of Appeal, who was himself a management side lawyer, and saying, yeah, this is absolutely a violation of constitutional rights. You need to have all these really strong elements that are necessary to support meaningful collective action. The Ontario government appealed the decision. We went to the Supreme Court, and the Supreme Court basically changed the yardsticks. And this is what happens in law, that a challenge like this, and at the first level, this is a case that a quote from a judge that I tell people all the time, that I was making arguments about why workers need the right to collectively bargain, and the judge interrupted me and said, "Ms. Faraday, are you challenging capitalism?" I kid you not. And I was like, yeah, because that's made of laws, and yeah, it's not fair. It's not immune to challenge. But I got to the Supreme Court of Canada, and Chris with Justicia brought in busloads of workers. The courtroom was overflowing. They had an extra courtroom set up for the workers to watch the case, to be there. And I sat in that courtroom, and I've never been so ashamed in my life, because the conversation that was happening between the judges and the lawyers was at a level that completely dehumanized what was happening. It was all abstract principles that have nothing to do with real people. And I sat there profoundly ashamed that there was no recognition of how this profoundly affects people's daily lives, and how the denial of their humanity and the basic right to join with others was a theoretical, not a real thing for them. The decision came down, and the court said, the law that we have here actually allows people to bargain collectively and to unionize, even though it doesn't. It said that, all it had was a right for workers to make written representations or oral submissions to their employers on specific topics at a time that is not inconvenient to the employer, and all the employer needs to do is to acknowledge that they heard them. And the employer need not do that if the submissions are repetitive. So all you need to do is say, yeah, thanks for the paper, and you keep telling me you want rights, but I've already heard it once, so I don't need to listen anymore. No right to a collective agreement, no enforcement, anyway. And the court said, that's a right to unionize, and that incorporates a right to good faith bargaining. And we have no evidence of any sort of discrimination against workers. We can't even address the issues about discrimination because we have no evidence of it. And I'm sitting there going, I have 40 fucking boxes of evidence, and you say in your public document there is no evidence? I honestly nearly quit the practice of law. I've never been so ashamed of the legal system as that case. Every single principle that I argued in that case is now the law, was adopted in 2015 in the trilogy of cases that labor law cases that was decided in January, which again I was a part of, but every single principle that I argued is now the law, and yet farm workers do not have the right to organize because it too profoundly disrupts that power imbalance that is necessary in order to have cheap farm labor in Ontario. And I can't think about that case without swearing. So there's a lot of fight left for us to do. I think that trusting the system is a dangerous thing, because what will happen, the further you are from the dominant population, the more your stories are not believed, the more your stories are considered not credible, and the more that the rules of the game will change in order to preserve the power relations that exist right now. And that is the reality of the legal system. There's much more to say, but it sticks with me.
I think this is a great time to break for some questions.
Or rally.
Yes, thank you.
Hi, did you see the judge after the law changed? The same judge?
The panels change all the time, but I had quite a delightful experience of speaking at a legal education seminar very shortly after the decision was released, speaking about the decision, and one of the judges from the Supreme Court was in the room, and I did not hold back in my criticism of the decision. It was profoundly the intellectual gymnastics that were required to come to that result are extraordinary, and yet that the extent to which judges will invest that effort to preserve power relations is not unusual.
What's the status now? Is it contested?
There's nowhere to go with it. The Supreme Court is the last level of appeal, and so we took that into the Changing Workplaces review, and the special advisors on the Changing Workplace review said, yeah, this is a problem. You need to, they had quite strong language about its lack of constitutionality. And when Bill 148 came out, I was in there with many other comrades making submissions about how this is a no-brainer, you have to change the law, and the government chose not to do it.
Yes, Jen?
Two questions. Following immediately on that, did the government, has anyone from the government ever been asked, to justify why they didn't accept that recommendation? And then the second question is about EI and whether there's any hope of changing the exclusion of migrant workers that Stephen Harper brought in. I know I've written my own MP many times about it, but what can be done?
I have spoken to, I can't even tell you how many people in the government, they are sick to death of me on this topic. They don't want to do it because they're scared of losing rural votes. That's the bottom line. It's not principled in terms of what's the law, what does justice mean, what do our constitutional rights demand. It's about who's going to get elected. And the only way that you can counter that is by making them unelectable for taking the wrong stance.
Yeah, maybe I'll just try to come in on the EI point question. I mean, for me, our strategy has shifted more to organizing as rather than bringing a legal challenge to the exclusion of migrant workers from parental benefits and other EI benefits. So, every chance that we get in terms of making submissions to government, it is a key thing that we raise. We raise it with any groups that, I'm part of a network of employment insurance advocates across the country where we try to work together to improve the program, and that is one of there's like 4 key demands for changing the employment insurance program, and that has now, there's kind of a national consensus amongst EI advocates that is a priority. Canadian Labour Congress brought that as one of their demands when they were lobbying the federal government. But I can't say that there has been, that I feel very hopeful about it at this point. You feel like you should just be able to explain it to somebody and they'll be like, oh, that's totally unfair, I'm going to change the law. That, they want it to work this way. They know that it works this way and they don't want to change it. So to me, I think our energies need to be more in organizing and gaining a consensus beyond the migrant worker community as well, within the migrant worker community and beyond, that this is what needs to happen. I think the solutions lie there.
But couldn't we do both? Couldn't we both organize? I mean, I'm not a lawyer, that's why I'm asking you. And I feel so strongly and passionately with this, as we all do. Is there no legal avenue to challenge this? Because even if we organize, even if we convince the so-called progressive liberals, then that's conservatives want to take it away again.
Just to jump in for a sec, because I'm just thinking of a conversation that that the three of us had before. There are discussions among lawyers happening right now about this being a discriminatory exclusion, and that it could be contrary to the charter, and so I think there are grounds there potentially, at least for exploring the possibility of a class action on behalf of migrant farm workers for this exclusion. It's just about, a lot of times, about finding the resources for that, because it is a huge endeavor to take on, right? And it's not as though the legal community is lining up to do migrant worker activism. Like, you have a good chunk of the people in front of you right now, at least for Toronto, unfortunately. So if they were to, blow up the building, they take out a lot of their opposition, at least as lawyers are concerned. And I'm sure they'd be more than happy to get rid of Chris as well. But no, I think you can do both. I think there's definitely room to do both. But I agree 100% with Jackie as well that it's essential to have broader support from the wider community for those rights. I think that's the only way. Apart from litigation, migrant workers themselves calling for it is not going to get changed. And I just want to very, very quickly say I agree 100% with everything Faye said about the Fraser case, and I'm saying that as someone that was absolutely not involved with it. Completely correct criticism of it. It is I think you called it intellectual gymnastics, and to come to that decision, and that's exactly what it was. Having read the decision more times than I would even like to think about now, trying to understand it. So.
Yes, maybe one more question.
I was wondering, I was talking with a farmer actually this morning in this forum, and he was telling me how he has been a farmer, and now he's an employer, and he treats his farmer workers as a family. So I don't know, it might be a little naive, but taking your point towards like how we go beyond the migrant workers communities, I'm wondering, are there farmer champions, like who really treat their workers well?
This is how I always answer this question. I'm going to speak for a little bit of time here. So good employers do bad things, and bad people do good things. There's a horrific asshole in Southwest Ontario who's done many, many horrific stuff. And they reached out to us to make sure that they didn't get in trouble because they had non-status workers. So he came out asking for help, pleading for help to make sure that immigration didn't show up to their place. Now I know a quote-unquote good employer on the east side of Ontario who basically listened to his head foreman, never really had an appeal system put in place, and would fire workers periodically just because the foreman would say so. So it's a structural issue. And I think this gets to two aspects that we need to really understand, that we have an adversarial system. We cannot, the program is run by employers, right? So employers, I think the phrase that we use is that they're your employer, you're a victor, and you're a deporter. And that in itself has to change, right? Employers should not be controlling this program, period. So there's a large power imbalance, first and foremost, and the relationship that exists is adversarial. And for us in this room, I want to challenge our moralities, all right? This is not just simply about saying, let's have a conversation. Let's have a great Canadian tea conversation with crumpets and Earl Grey tea, and expect the conversation to come up with a handshake at the end. No. Contracts are built on blood. The relationship's built on blood, sweat, and tears. And we have to basically engage in a confrontational relationship with employers. And I'm sorry, that's just the way it is. And the other part of the morality and the amazing work that we think that, okay, so a good employer may not do bad things. And IAVCO's taken on a bunch of cases of injured workers. And the employers are like, look, they never got hurt, right? And so many workers are sent back home. But luckily there's one guy named Kevon who's able to stay a little bit longer. And just because the support system, very half-assed system was put in place, but he was able to stay and fight his case. So many things showed up afterwards, right, about how his injury was work-related. And that was also the morality of the employer, and I think a larger community of thinking, well, yeah, so what? This guy should be just sent home, right? And the fact that those mechanisms are not put in place. Now, the connection, so morality is important. Adversarial relationships and understanding adversarial relationships are demands. And I think part of our failure in the beginning of the employment insurance conversation is that too many good-intentioned, well people were like, well, look, Migrant workers aren't getting the benefits of EI, so let's just scrap the program, abolish it for them. And even though that rhetoric was challenged afterwards, the fact that those basic principles were put forth gave the opening for the right wing to do what they're doing. I am hopeful, right? I don't lose my hope that things will change, whether we look at an organizing strategy or we look at a legal strategy. I think the important stuff of the EI community challenging its own goddamn racism about these issues and now accepting this is very, very important, right, as a first step. Now, the last thing I want to talk about is the right to organize. So the story, and I guess Stan Raper, who I worked with for many years, he's passed, and I guess I could share these stories now. The agricultural worker alliances, those different houses were basically, it wasn't a UFCW project. It was a project that was done by the United Farm Workers and the Canadian Labour Congress. The idea of those houses, when we came up with that, was, and very much today, I'm sure most of you don't know, but there's a war going on in the labor movement right now. And different entities within the unions are fighting each other. The objective back then was to try to, and this was our idea, it wasn't necessarily what other people were thinking, but the idea was to try to use the farm worker organizing as a way of trying to bring people together and try to bring different unions to fight together. And I want to be clear, if we're going to organize Tim Hortons workers or farm workers, it's going to cost hundreds and hundreds of millions of dollars. There's no one entity that can do it, none. And if we're going to win, we've got to put those reasons up. And people, the boys up the top, got to put their fucking egos aside and think about what's best for the working class. They can't look at migrant workers as the enemy, and they've got to think of that. If we're going to basically build organizing in the labor movement, you start with those at the bottom. And that was the vision of those houses back in the day. And I would basically invite you to start thinking, if we are serious about organizing, that's the model that we need to look towards, not this petty fighting that happens where everybody wants to try to maintain their little turf, and turfs which are becoming less relevant today.
Okay. I want to come back to that notion of I treat my workers like they're like family to me. And I honestly, the number of times I, sorry, I just don't, yeah, exactly. You can see. The number of times I hear that is astonishing. And when you hear those words, do they sound crazy to you? Yeah. Like, do you know, in your job, do you think of your boss as your family? Do you want to be your boss's family? What does that imply? Other than, you know, employers of caregivers say that all the time. Oh, they're just like family, but you don't let them sit at the table with you, and you don't let them eat the same food as you, and you make them work 24 hours. So I don't know, that doesn't sound like a nice family. That sounds pretty freaking dysfunctional. But the other part of it, what it does is it highlights the extent to which employers blur the lines deliberately. And whenever an employer says that, whenever a farmer says, I treat them like family, I think back to slavery and who's in the house and who's on the field, right? And the notion that there's that personal relationship that's not a work relationship is odious. Because it is used to manipulate a worker, and it's something that our seasonal agricultural worker program has built into it, because workers get to name, or employers get to name workers by name, whether to come back or not. So it, if an employer doesn't name you, you don't get to come back. So you have to have that relationship of gratitude towards the employer in order to be allowed to come back. So all those words of allowing and permission and gratitude are not things that should be part of an employment relationship. That is not an empowered employment relationship. But what lies beyond that, which makes me even more angry, is this notion that employers should be congratulated for complying with the law. Sorry, no, that's a given. That's a starting point, is you comply with the law, and you don't get, you know, shiny gold stars for that. The fact that others in your industry don't doesn't mean that you're a good guy. It means that you're complying with the law. And that should be the basic expectation. And when those laws are set at a level that facilitates, encourages, constructs relationships of indentureship, that is not being a good employer, right? You're operating in a system that entrenches privilege, and you're taking advantage of it. And so those personal attempts to not feel bad are not things that we should give into. I think they need to be very aggressively challenged.
I just wanted to add one thing as well. Those sort of comments I think of is, we don't live in family farms. This idea that there's it's agricultural business, and when they try to say these little stories, then they try to create a vision of little homesteads and people picking some eggs. That's not what's happening here. We're talking big agricultural business, and I just think that trying to have us think that there's a little cottage industry going on over here, and that's not what's happening.
Yeah, it's that myth of the family farm is
Yeah.
used to justify excluding farm workers from the right to collectively bargain. I mean, is
That's
that not
exactly
what you meant with?
the argument.
Yeah.
I completely agree with you, all of you, because when he was saying that, I felt like he's talking about patriarchal family, right?
Yeah.
And when Grace was saying that you must do this, right? You cannot even take a coffee break unless I give you the permission. It seems like that kind of family values he is bringing in. I'm sure that's...
Yeah, when you have your employer setting a curfew,
Oh my God.
that's not a nice family.
Oh, yes, we have another question.
I want to thank the panelists. It's been a very enlightening discussion, so I'm really interested in what you all have to say. I do have a specific question for Grace in terms of the Human Rights Legal Advisory Center. Does your role at the center, does it work a bit like the Office of the Worker Advisor, where you'll actually take on cases on behalf of people and represent them, or is it more just referring people to how the system works and then they have to go on their own and do that?
So we have a website, and I can give you more information about our center, but we provide legal, the whole spectrum. So we give legal advice, we have representation. We represented, 25,000 people a year call us. We interviews, we have, so then we have an intake line, and then we've had lawyer interviews with people, so that's, a 2-hour interview, 2,500 people. We represented about, actually no, our staff, but maybe 300 people at mediation, and then maybe another 100 people at hearing. So we have unbundled service. We have different services for different people. We try to serve the most vulnerable and those who have the most significant barriers to accessing justice on their own. So we can't provide full representation to everybody. So our service looks different for who it is and what the case is. But yes, we do represent people, not everybody. But there is no income testing, so that's the one difference with respect to, not that this client group would be able to access, but we don't have income testing, and it's across the province.
What does that mean, income testing?
But, legal aid has these ridiculous cutoffs, so you have to be absolutely living in poverty before you can access services. So anyone who's worked actually never is able to access legal services through Legal Aid Ontario, unfortunately. So we don't have that income testing.
Thank you so much for all of the work that you do. I know that if you were paid by the hour, that you'd be definitely in the hole. I want to take it back to some of the early conversation about consent. I think Grace and Jackie both mentioned it a fair bit. I'm a clinician, and so the issue of informed consent is sacrosanct to our practice. And so when we are talking to workers about filing WSIB claims, this is probably the most common conversation that we'll have in terms around consent and the concerns around that. And in the clinical setting, if we are going to submit a WSIB claim, I'm with the occupational clinics, and so we do spend the time to try and explain what WSIB is about and potentially what some of the outcoming issues may be. Usually takes between an hour and a half, somewhere between an hour and a half, in terms of the clinic time to pull somebody aside to try to do that. At the end of all that, are we confident that we really have an informed decision? The answer is no in most instances. And so I just wanted to ask if you can comment just about that level of confidence around consent and perhaps how that affects your work.
Okay. So in the legal context, we talk about capacity. So consent is about sharing information. So if everything my client tells me or anyone who gets advice from me, they are given a promise of confidentiality and won't share that with anybody else without their express permission. So that when I talk about consent, I meant if I want to talk to other people, I get their consent. In terms of acting for somebody, in the legal world we talk about capacity. Do they have legal capacity? It's a pretty low threshold. Do they understand the outcome, the potential outcome of what their next action is going to be? And in our practice, we think about, people have different levels of capacity. People can come in and out of capacity. I try to take instructions when I can. We like to have, sometimes people need to have other people assist them in decision making. Assisted decision making is something that we incorporate in our practice. So I may have a client who may have intellectual disabilities and rely on a friend to help them give me instructions, and we'll take instructions that way. So I think and the use of translators and all sorts of other, maybe other types of communication assistance. But it is I wouldn't take a step unless I knew that the person I had in front of me knew what they were doing and agreed to what they were doing in the legal context. And I'm pretty confident that my clients are able to give instructions.
Yeah, I mean, in my experience, like nobody knows better the risks they face than the workers themselves, and nobody is better placed to make the decision about if it's good for their lives to bring the case forward. The technicalities of a particular legal argument, actually, they're pretty good with too. I think if you, as Shane said, you take the time and you work with people and you develop a case with instructions from the workers themselves. So I could see it being more difficult perhaps in the health field, but in the legal field, I actually feel, I've always felt quite confident that the workers understand very much and they are well placed to make decisions about what's best for them.
And I think, sorry.
Yeah, no.
No, I was just going to comment on that because I think that in the case that I'm talking about is that the workers don't really know what the risks are. And as a clinician, I don't really know what those risks are because, all the cases that you're talking about. So it's difficult to really file proceed with WSIB claims because we think that that's important and that there are advantages for the workers. There's definitely advantages for them to identify hazardous working conditions, etc., to get that going. But I don't think, at that point in time, I don't think that any of us know what the outcome of the well, maybe the potential outcomes for those workers, but we really, really don't really know what the risk is.
Maybe I could speak to that one because that's a little specific to workers' compensation, which is what we do. So I think there are a lot of risks, and it really can be really difficult. I agree with Jackie. I mean, in general terms, of the workers we've spoken to do understand the risks and are the ones to generally voice those risks to us rather than the other way around. But that said, we might be speaking to people who are already understanding. They may have called our clinic because they've said, listen, I'm injured. This is a risk I have to take. I'm beyond a choice here, and this is the choice I'm making, and I understand the risk with it. So it may be that because they're calling us, they're already in appreciation of those risks, maybe because of the work you guys are doing, other people, grassroots organizers are doing, OCAL's doing. She kind of already had spoken to them about that. So, it's hard to say. And there are also risks that are kind of unique to the particular structures around the migrant worker programs. It creates risks that are actually even like things that people may not know, that there are actually, because there are structural risks between the various governments and how there might be retaliation that is beyond just by the employer, that many people know about and many people may not know about. Even some of the stuff was kind of news to us when it started happening. So those are critical, but generally we do find that the workers who at least are in contact with us are aware of the risks. I don't know what recommendations to make other than if workers are willing to talk to someone who's a little more enmeshed with how the particular legal framework is around workers' compensation, I mean, that is great if you can get them to call, a legal clinic or someone who's an expert. That obviously is kind of best case if it's possible.
One thing to just follow up on what Meredith said, and I'm going to try and condense this long story to as small a package as I can, but the DNA case that Chris had mentioned is kind of a good example about consent and capacity and knowledge and knowing about risks. So long story short, 2013, there was a sexual assault in the Bayham area of Southern Ontario. That's near Tillsonburg. The police had a very specific description of the suspect: height, weight, skin color, hair, everything, age, so on and so forth. What they ended up doing was they set up a perimeter, this particular radius around the area of the assault, and they went to all the farms in the area, and with the assistance of the farmers, at nighttime they would go to the bunkhouses where the workers were at, and they would lead the workers out one by one, and they would put them into a locked police vehicle, and they said, this is entirely voluntary, but this is your chance to clear your name if you'd like, and you can give us a DNA sample, and we can rule you out as a suspect. Now, despite knowing that the person was in their 20s, that they were approximately 6 feet tall, 180 pounds, muscular, no facial hair, short hair, and that they were described as being black, they went and they targeted people in between the ages of 19 and close to 60 that weighed just over 100 pounds and that weighed over 300 pounds. People that ranged from height of about 5 feet tall to over 6'3", long dreadlocks, gray hair, beards, you name it, people that were West Indian, people that were black, you name it. Anybody that was black and brown in this area, they took them out and they put them into this locked police vehicle and they made this demand for their DNA, right? Something that we would never see in a million years here, right? Everyone except for 2 people went ahead with this. They felt as though they had absolutely no choice whatsoever. One of the people that refused to go ahead with it was never brought back on the program ever again. He was banned from the program. What ended up happening is that so they did this to 100 workers in the community. 54 of the workers eventually came forward as a group because there was this widespread apprehension and absolute fear of doing anything. People knew that what happened was wrong. They were very upset by it. But there was just a complete fear. There was a lack of awareness about what their rights were as well. And they just felt as though they couldn't come forward or they were unable to come forward on their own. So with time, they were able to come together as a group, and 54 of them together filed applications at the Human Rights Tribunal. And going through, and that was a case that Chris and I are involved with, and going through that process to have them know about what the risks are in filing an application like this was extremely time consuming. And trying to develop new ways and systems to give people hope and safety and security, saying, we're going to do contingency planning. If there's a reprisal, this is what we're going to do. And that was mentioned earlier as well. And trying to develop systems about how do we handle something like this? There's so many people. How do we make sure that people feel safe and comfortable coming forward? And like I said, it took a lot of time, but people were eventually able to overcome this fear as a group. They came forward, and the government fought back on it. They tried to have the case dismissed because they said the workers took too long. But we just recently, about a month ago, got a decision back from the tribunal saying that no, in fact, the cases are going ahead, which is very, very uplifting to everybody. And so that's an example, though, of where people can know what their rights are, and they can also know what the risks are. But even if you're fully informed about it, that overarching fear can just sometimes, it's one of the most controlling elements, it seems, for people that are on the program, because one of the things that we've kind of mentioned up here, but we didn't go into a lot of detail, is that the contracts that people come up on, and remember, these are contracts that the workers have no hand in negotiating whatsoever, mainly because of what Faye is saying, that they have no right to collectively bargain, they have no seat at the table. These contracts that are negotiated between the government of the sending country and the Canadian government and the employer's representatives have a clause in them that allow the employer to send a worker home at any time for any reason whatsoever. They don't have to give an explanation to anyone. All they have to do is notify the liaison office of the sending country that they're sending the person home. So if a person comes, if a female worker gets pregnant while she's here, they can be sent home. If a worker gets injured, they can be sent home. Like in the case of Adrian, if somebody complains about racism in the workplace, they can be sent home. Or in this case, like we saw, somebody refuses to give a DNA sample during this racist police investigation, they can be sent home. So it's the fear. People, as much as you know about what your rights are, it's about exercising them. And until we actually have legislative changes and changes to these contracts, you can know as much as you want about your rights, but if you can't practically enforce it without, permanent exile, it's not really that useful.
Until you have permanent status on arrival.
Yeah,
Exactly.
So I think that's the important part here. Is so our demands, they're basically about creating a vision that's different from what's currently happening today. And I think this is one of the ways to challenge these this idea of fear. And Jackie's absolutely correct. The reason why we call for permanent status on arrival is to take away the power of employers to divide workers based on immigration status. To recognize that historically when white farm workers came, they had access to permanent residency. And just simply because it's black and brown bodies from the global south, they've changed that. So it's about saying that our immigration laws need to change and to ensure that people arrive with full rights. And simultaneously also just changing our social safety net, both at the provincial and federal level, to make sure that workers don't fall through the cracks. They have equal access to healthcare, equal access to education, and also to ensure that people aren't paying recruitment fees or being sent home when they stand up for their rights. This week I've gotten several calls from workers who've been banned from the program, and they want a chance to come back, but they are facing this banning. So think about how do we make sure that that happens. And I think as all of us in this room, and as the issue becomes more harder and more people become involved in this issue, the challenge for us is not to engage in being gatekeepers, making sure that we're not containing, controlling the crisis that migrant workers are facing. So it's about supporting and pushing forward these demands and saying that there are possibilities, right? Yes, workers are exploited and vulnerable, but workers have engaged in marches, they've engaged in protests, they've resisted the ability to go home, right, to try to get decent health care. And I think we owe it to them to push for a vision that basically takes away the power of employers and the government to regulate those bodies here in Canada.
And sorry, the one other piece is the single source employer.
Yeah,
that you're employed,
ribbons.
You're tied to one employer, you have no labor mobility.
I think that's a great note to wrap up, as we're standing in the
We missed our entire other half of our presentation.
Well, I think we hit a bunch of it.
Let's wrap it up, and if anyone would like to sit down and talk with you guys, that would be, we would welcome that. But the time is up, and we are just being mindful of your time.